All right. Well, thank you everyone for firstly sticking around. And Mark said to us when we were, talking about what topics, he's like, you guys are the headline act, but actually this is really the graveyard shift that is standing between you and drink. So we'll try to get through reasonably promptly. We also have a disclosure. There is no animation whatsoever on these slides, but what we have is hard data and some very, very nerdy chat about liability and indemnities. So one of the most common questions we get asked when we're assisting on deals is what's market? People want to make sure that they try to get to a contract pretty quickly. It's only the lawyers that like to spend time arguing about certain things. But people really just want to make sure that they're not having to report up to their board that they're accepting positions that others in the market aren't accepting. And if you're on the supplier side, you want to make sure that you're not giving away more than you need to and what your competitors are doing. So what we've done over the last 4 years is each year we've surveyed sort of the big technology deals that we've done as a firm. And so this ranges from sort of IT outsourcing, big systems deals, but anything of a particular size. And we've sort of looked and analysed that data, and we've tracked that over a 4-year period. And what we've done today is extracted some of that data, and we'll be looking at some of the key findings, but specifically in relation to liability and indemnity positions on both customer and supplier sides. But we have actually focused this year on deals where data processing is quite a material part of the transaction. And so we'll be looking at the specific treatment of data protection risks from a liability and indemnity perspective. And for that, I'll be calling on my data protection expert, Faye, to assist us with that. Different from the other presentations, we're very, very happy to take questions, comments, observations as we go along. So if we say something which you violently disagree with or you want to know a little bit more about, feel free to stick up your hand and we'll try to get a mic across to you. So over to you, Faye.
Okay, so we thought we'd start with suppliers' general liability under contracts. And this kind of shows the contracts that we surveyed over the sort of 4-year period. And one of the key things that we noted is that every single contract we looked at capped suppliers' liability by reference to the fees under the contract. So you can see that's across every year, always 100%. The other thing we noticed that these caps are often also linked to a kind of minimum liability floor. So that's the idea that you've got kind of the cap on the supplier's liability will be the greater of 150% of the fees or a figure such as 5 million. However, this trend seems to be kind of going down. And as we get towards 2022, we're seeing more contracts where there's just a fee-linked cap rather than a minimum liability floor as well. We think this might be partly to do with lots of contracts now having separate caps for specific kind of key risks. In terms of the average value of the fee-linked cap, we often get asked about this. The graph shows that this is kind of gradually going up between 2020 and 2022 from kind of around 150% to more like 180%. However, we think there were some outliers in our data for 2022. We had a couple of fairly unusual deals where they'd agreed to sort of 300%. So we think this has skewed the data a little bit because our more kind of general feeling that we're getting is actually suppliers are becoming a bit more conservative and that these values aren't going up and they are sticking more around about the 150% mark. So that's just an observation. I think the other thing is that customers are starting to get a bit more comfortable with these lower caps, just because, as I mentioned before, we're seeing more of these separate caps for specific issues. So where there is a key risk that they're particularly worried about, like data protection, it's dealt with elsewhere. The other thing we thought was quite interesting is that when you've got a fee-linked cap, it could be by reference to just 1 year's fees under the contract, or it could be the total contract value. And actually what we found is that more often than not now, we're starting to see it being linked to annual contract value, so just 12 months fees rather than the full term of the contract. We've even seen this a few times in contracts that are kind of purely billed. I wouldn't say it's a trend for those types of contracts, but it's something worth noting. It could also be indicative of the particular sample of contracts we were looking at. A lot of the contracts involved had a kind of quite a large build, but then also a large run component. We also looked at lots of agile deals, so there's kind of less of a clear distinction between when is build and when is run. So that might have influenced our data. But overall, we do think that it's becoming more the case that these fees are linked to just 1 year's fees. Sorry, the caps are linked to just 1 year's fees. If we could move on. So this is looking at kind of areas where you've got maybe a separate cap or an uncapped liability. And these are kind of the sort of key areas where we see this happening. One of the interesting things from a sort of data protection lawyer's perspective is that in nearly all of the contracts we surveyed, data protection was carved out as a kind of separate cap or a super cap. You can see that it's sort of a fairly steady trend over the years around the kind of high 80s, 90%. So everyone is now looking to carve data protection out. At least half of the contracts we looked at also had some kind of additional, either a separate cap or an unlimited liability carved out. So this was things like employment and 2P, willful default and abandonment. So we are seeing, as I mentioned earlier, lots of contracts that in addition to your kind of general liability cap, they have these separate caps or unlimited liabilities for specific issues. Again, the trend is kind of staying fairly steady. The employment and 2P ones maybe gone up slightly between 2020 and 2022, but we're not seeing any kind of huge changes across the data that we've looked at here. One thing that's quite important to think about if you're drafting contracts is that the more of these separate caps and the more of these kind of separate unlimited liabilities that you have, the greater the risk of overlap between these different areas. One example that's quite good to look at is willful default. This is an area where you'll often see unlimited liability. But if you think about a contract where you've got a separate cap for data protection, for example, if there is an intentional breach of the data protection provisions, will that come under the data protection cap for liability, or is it willful default and so it's unlimited? That can be quite a tricky one. Contracts often don't think about it. They don't look at the sort of overlap between these different provisions, and you'll probably find that the customer is saying, well, it's unlimited liability, and the supplier is saying it's capped. So it's important to make these things really clear in the drafting. And certainly from a supplier's point of view, we're often seeing sort of debates over the definitions of terms like willful default. And so you want to be trying to make that as narrow as you possibly can to avoid this risk of kind of overlap and potential kind of contradiction with the data protection terms. I think Adrian's now going to speak about supplier indemnities.
Yeah, so how often do suppliers give a specific indemnity, and in how many cases were they capped? So really what we sort of have seen over a period of time, but definitely this year as well, is that like other than for IP and 2P specific indemnities, I'd suggest that customers are getting a bit more comfortable not holding out for unlimited liability or uncapped indemnities. And I must say, even on IPR indemnities, which I think everyone would agree traditionally have always been uncapped or unlimited, we are seeing actually a bit of a creep that they're getting capped in certain cases, and that's happening a little bit more. Not a massive trend yet, but we're just seeing it more frequently. And 3-5 years ago, that would be very, very rare. Another area to watch out for, especially if you're on the customer side of things, is there's a bit of a trend as well, seeing sort of even UK-based suppliers adopting a slightly more American approach to how they deal with IPR infringement. You might be familiar with some of the sort of bigger US vendors with, how they deal with sort of software copyright infringement provisions. And what they'll do is they'll give you a non-infringement warranty, but then back that up with an indemnity for breach of that warranty. And that, on the face of it, looks fine. You think, okay, I've got a non-infringement indemnity, but actually, you'll end up carrying the cost of any type of claim and defense of that up until the point that there's a proven infringement, because up until that point, obviously, there's no breach of warranty. So we've had a few circumstances recently where we've been acting for clients who have received claims, and specifically in areas where the technology might be quite a fertile ground for non-practicing entities or like patent trolls. This is becoming a really big issue because you'll get a claim or a letter from a patent troll saying, you're using our technology, you're unlicensed, let's sort it out. Not a lot of those end up in court, and where you often end up is in some type of licensing and settlement discussion. So if that's the case and you end up having to settle because you don't want to actually take it all the way to court, you won't be able to claim on the indemnity because there's actually been no proven breach of or no proven infringement. So it's something to look out for. If you're on the customer side and if you're on the supplier side, it might be something to think about as a way you can try to manage that risk, because that risk also exists really for suppliers as well, who are potentially going to be subject themselves to some type of patent troll claim, or a lot of their customers will be. You'll also see on the graph here on the far right that there is a pretty low percentage of indemnities given for security-related issues and also third-party claims generally, but separate from an IPR infringement claim. And that's pretty common and sort of similar to what Faye was saying before. I think that's because people are just being a bit more specific about what they care about. So that general catch-all as for an indemnity for a third-party claim for anything, we're seeing a lot less of. Data protection, still reasonably common, but actually over time we have seen it drop a little bit. And we'll talk about whether or not that becomes a real issue down the line for customers who may not be getting a data protection indemnity. Sort of my general feeling is actually overall, customers aren't being left in a worse place, even if they don't have that DP indemnity, because a lot of them are dealing with it through the liability provisions and the deemed direct loss provision. So it may be harder to get a specific indemnity from a supplier, but there's a bit more movement around what could be a deemed direct loss to help you recover for certain specific data protection issues. All right, so talking about DP, let's shift our focus a little bit to data protection.
Great, thanks, Adrian. Okay, so just looking at our diagrams here, so the first one, top left, you can see that for the second year running, so 2021, 2022, all of the contracts that we looked at caps data protection liability, whether this was a separate cap or a kind of super cap topping up the general liability cap. If anyone can remember the world before the GDPR, things looked quite different. We would often see contracts with unlimited liability for data protection breaches. Possibly a lot of that was to do with the fact that potential fines were far lower. There was perhaps less exposure to fines because there weren't so many compliance obligations. People were less worried about kind of group litigation orders. And I think even just generally there was less awareness. Suppliers didn't see data protection as such a big issue. So we often saw it as an unlimited liability in contracts. GDPR came about 2018, huge new fines, everyone starts worrying about group litigation, and suddenly we were seeing customers pushing for unlimited liability or sort of huge caps in the millions and millions, all terrified about these fines and needing their suppliers to protect them against everything. Equally, suppliers were terrified about the fines and desperate to cap their liability. So we had this kind of situation where we didn't really know what was market, what was reasonable. The parties are sort of each at one end of the spectrum, and we didn't really know where to meet in the middle. I think as time's gone on and we've all kind of got accustomed to the GDPR, things have settled a little bit. Regulator fines for GDPR breaches aren't very common in the UK. We've only had, I think, 5 ICO fines this year for GDPR breaches, which is very few. We've obviously had the Lloyd and Google case, which means that people are now not really so worried about class actions. So I think overall people are a little bit less worried about the kind of implications of these huge risks. So as I said, suppliers are sort of as standard capping liability for data protection breaches now. And if you look at our second diagram on top right, the vast majority of these contracts have a separate cap for data protection rather than a kind of uplift, so a super cap, which I think seems to help customers get comfortable that they are protected in this area. And you can see there's been a slight increase over the last kind of 2-3 years from about 78% of contracts to 88% now having that kind of separate cap. And yeah, not really seeing the super cap so much. Similarly to what we mentioned about general supplier liability caps is that these tend to be calculated by reference to fees under the contract. And where for general liability you might see levels of kind of 150 to 175%. For data protection it seems to be significantly higher, so more around the kind of 200 to 300% mark. That seems to be kind of fairly constant. It's not going up and down hugely. That seems to be what we kind of see across the majority of contracts that we look at. Moving down to the bottom left, so most of the contracts that we looked at had deemed direct loss provisions relating to data protection. So for things like regulatory fines, we think perhaps because regulatory fines are fairly rare in the UK, that this is something that is likely to be considered an indirect loss, but customers aren't quite comfortable to just not worry about that risk at the moment. They still want protection, and so instead they want this to be a deemed direct loss that they can hopefully recover. And so that's what we're seeing a lot more in contracts. Conversely, in terms of data protection claims, only sort of 14% of contracts in 2022 we're deeming that a direct loss. And you can see from the data it's gone up slightly, but there's not been a huge increase. It's not something that customers are demanding, and I think perhaps Lloyd and Google has influenced that. Adrian is going to speak about deemed direct loss in a bit more detail later on in any case.
Yeah. And sorry, that last one I think is specific to sort of deemed direct losses for data subject claims, so separate from any sort of regulatory actions.
Oh, sorry, is that not what I said? Sorry. Data subject claims. Okay, so moving on to data protection indemnities. So as Adrian mentioned earlier, we still see these in quite a lot of contracts, but you can see the trend across 2020 to 2022 is that they are decreasing. I think, again, the 2022 data might be a bit of an outlier. It shows quite a dramatic drop, which perhaps isn't quite reflective of what we're seeing in the market. There could be a number of reasons for this. We think possibly it's down to the types of suppliers. So if they're kind of lower tier suppliers, possibly not in a position to offer indemnities so freely, perhaps customers aren't pushing for them so much. So we are seeing a kind of general trend to go down, but perhaps not as dramatically as that data would show. I think one thing I've noticed, I mean, I don't really look at technology contracts so much, but I do look at a lot of data processing agreements. And I think what I noticed was immediately post-GDPR, we had these very kind of one-sided DPAs coming out with customers wanted every indemnity from the supplier, and supplier wanted indemnities from customers because they were all terrified about GDPR and these huge fines. And I think as time's passed, that has calmed down. I think we're seeing a lot more sort of reasonable starting positions, kind of middle ground. We're not seeing everybody ask for indemnities in every single agreement that we see. I think that customers are getting more comfortable because they have got these separate higher caps for data protection breaches, so they don't necessarily feel that they need to demand an indemnity as well. And also we've got often obligations on suppliers to take out cyber insurance, so this gives customers an added layer of kind of comfort. So perhaps indemnities aren't becoming so important to them. In terms of customer indemnities, as you can see from the data, we're really seeing that these have gone down massively. Even in 2020, we're only seeing them in about 25% of contracts. Now it's gone down to about 11%, which is interesting to see because, as I said, straight after GDPR, every supplier wanted its customer to give an indemnity. I think this is partly due to the fact that we're not really seeing processors getting fined for issues caused by controllers, so suppliers are less worried that that's going to be an issue. I think also just having discussed this with suppliers and sort of putting in place their standard agreements, they don't want to have protracted negotiations on these issues. They want to start with a kind of more reasonable, customer-friendly starting point, and so we're really starting to see these kind of fade away. And I think Adrian was going to pick up on a specific point around conduct of claim.
Yeah, so if you look at the bar chart on the left there, so the 2022 figure, it's got quite an interesting stat that half of the contracts which had some type of data protection indemnity in them also were coupled with a specific conduct of claim provision. So a lot of you will be familiar with getting a third-party IPR infringement indemnity, and that being subject to, or at least part of parcel of that, is there being handing over conduct of the defence to the indemnifying party. So we've been sort of talking about this a little bit over the last few years, but it's been quite dramatic this year that in half of the arrangements where there was this type of DP indemnity, there was a conduct of claim provision as well. And that's gone up, back in 2018 when the GDPR came out and we ran the same survey, it was only at 10%. It's grown to 30, 43 last year and up at half this year. And this is a really good way for suppliers to manage the risk, right? Like if you're going to give an indemnity for data protection issues and you're worried about regulatory fines or data subject claims and class actions, although taking what Faye mentioned into account that maybe in the UK at least, group litigation orders might be a bit more difficult to bring after Lloyd and Google, there's still a need for suppliers to try to mitigate that risk. But what we're also seeing is customers, if they're fairly well advised, thinking about a slightly different relationship that they have in this indemnity situation. Obviously in an IPR infringement indemnity claim or an IPR infringement claim, people are at loggerheads and there's no sort of ongoing relationship you necessarily have to worry about. But if you're talking about a data subject claim, these are most likely going to be your valuable customers, and you may not want to actually hand over control to someone else whose sole objective is to minimize the liability. You've got to think about that ongoing relationship. And that's the same with the regulator. You know, obviously you'll go pretty hard at a regulator, but you will still be regulated by them after the claim. And there's the other nuance about regulatory actions in that, you know, it's pretty unlikely that a regulator is going to actually talk directly to the indemnifying party, even if you've handed over conduct. They're just going to want to talk to, you know, the controller or the processor or whoever it is that they're investigating. So what we're seeing a lot more now of is these types of conduct provisions, but they're not the straight carryover of the IPR indemnity conduct of claim language. We're seeing a lot more discussion about sometimes the indemnified party still maintaining control, but taking on obligations about consulting, you know, with the indemnifying party, allowing them to make representations, you know, even in some extreme cases, you know, taking an obligation to have, you know, reasonable regard and incorporate reasonable representations that the indemnifying party is making. So, you know, there are a few other things where, you know, you can ask for like advanced copies of correspondence before it goes to the regulator, so you've got that opportunity to comment. So I think that's going to keep growing, maybe not as much in the UK in terms of group litigation orders, but on the continent where they're still quite concerned about class actions, I think we'll see a bit more of that.
Okay, so because we're talking about data protection in a sort of contract context, we thought it would be useful to also touch on confidential information. One thing we thought was quite interesting is that across the board of the contracts we looked at, around 60% of them impose strict liability for confidentiality. And essentially what that is an absolute obligation to keep data confidential. Traditionally, you may have seen more sort of reasonableness requirements or these clauses that say things along the lines of the supplier needing to keep data confidential to the standard it keeps its own data or own confidential information confidential. So we're seeing less of that and more of these kind of absolute obligations around confidentiality. And we think that this might be partly to do with the interplay with kind of security and data protection. You often see personal data included within the definition of confidential information, for example, and with the kind of high prevalence of cyber breaches, data protection breaches, customers are getting nervous, and so they're wanting this higher sort of absolute standard of confidentiality. Just looking at the slide, you can see that there's a fairly consistent increase from 2020 to 2022 of liability for confidentiality breaches being capped. And I think sort of traditionally, and certainly back in the day when I was more of a contracts lawyer, confidentiality is one of these areas where you'd often see unlimited liability. I'd hesitate to say that it was probably the standard position. So it's interesting to see that sort of over even just the last couple of years, we've seen a significant increase in that being capped. I think this might tie in with the fact that a lot of these contracts now have this strict liability, this kind of absolute obligation to meet confidentiality standards. And so suppliers are getting a bit more jumpy. They're also thinking about this kind of overlay with security and data protection. And so they're feeling the need to cap their liability in this area where perhaps they didn't previously. Another area of complexity that we often see in contracts is the sort of defined terms. So you might have, as I mentioned, personal data included within the definition of confidential information, but you might then also find confidential information within the definition of IPR. So you'll have confidential information obligations, IPR obligations, data protection obligations, and they all seem to sort of sit on top of each other because of how the terms have been defined. And it can get really confusing, it can be really unclear which obligations apply. So it's really important to get those definitions really clear to try and avoid this overlap if you can. One area that can be quite interesting is where you've got personal data within the definition of confidential information, as I mentioned. You've got a cap on breaches of data protection liabilities, but perhaps you've still got unlimited liability for confidentiality breaches. And then you've got a sort of back door, if personal data is in the confidential information definition, to getting unlimited liability for a personal data breach. So you've got to be really careful with the drafting and either take personal data out of that definition, so it's not covered at all, or make it very clear that the cap will apply to confidential information to the extent that it is personal data. So just lots of kind of important things to think about when you're drafting these contracts, because often people don't think about the interaction of all these different clauses.
All right.
Okay.
Turning to the customer's liability cap. So usually not quite as contentious as what the supplier is willing to give, but you know, from a customer's perspective, maybe still helpful to know, you know, what you should be agreeing to in respect of your own liability cap. And the first point I wanted to make, which isn't on the slide, is that the data's been pretty consistent over the years, and it was the same last year. In about 80% of the agreements that we looked at, the customer's liability was just capped by reference to the fees only, so no de minimis. And in almost all of those cases, it capped out at 100% of the fees paid under the agreement, or depending on sort of how the charging mechanism worked, on an annual basis. But pretty much 100% was the standard there. It's also not as common for customers to have to accept sort of carve-outs from the cap. So it was only in 50% or half of the agreements that we looked at that the customer had to accept any type of carve-outs. And you can see the types that were carved out in those half of the sample. So IPR, TUPE, willful default and abandonment being the three most common. And on IP, it's dropped a little bit. This is the first year it sort of dropped in that sort of way. Maybe a bit of a trend, maybe customers getting a bit more conservative about what they feel they need to give. And also I think suppliers are taking a bit more of a pragmatic view. Do you really need like an uncapped IPR indemnity from a customer if actually there's not a lot of access to customer materials? So we have to wait and see whether that becomes a bit more of a trend. But what was quite surprising was that customers are still giving, either an uncapped or at least a carve out from their liability cap for willful default or abandonment, because I know there's some suppliers in the room as well and they might have a slightly different view, but I'm not sure if it's a massive worry for suppliers that there's going to be some type of abandonment or willful default by the customer in their contracts that require them to have a higher or a totally uncapped liability. Maybe there might be some instances if you feel like the customer's really fast and loose with consent or something like that from a data protection position, but otherwise, like, my sort of sense is this isn't a huge issue, and maybe it's just reflective of customers taking quite a pragmatic view and thinking, well, I actually really want unlimited liability from the supplier for willful default and abandonment, and maybe just agreeing to that being mutual is a way to help that negotiation discussion go, so you can give something a little bit more easily to get something back that might be a little bit more useful to you in the long run. And now looking at customer given indemnities. So for the suppliers in the room, what are customers giving indemnities for, and to what extent are they actually trying to still cap their indemnities? And so as you would expect, not super common for you to really need or to ask for customer indemnities, with the exception of IPR infringement or even IPR breach if there's a big sort of software licensing component to your arrangement, and also for TUPE, like if you've got some type of service provision change or ongoing run where TUPE is a risk. So customers are still giving IP indemnity sort of more often than not. So in about 50% of the cases that we saw, there was that type of indemnity, but it has dropped a bit from the previous year. And I guess one sort of thought about why that might be decreasing is, with this big push for digital transformation, so maybe organisations which aren't, as I think Mark was saying at the start of today, maybe not inherently identifying as a technology provider or technology company, lots of their digital transformations are based around out-of-the-box solutions. Like CIOs are just trying to minimise how much customisation they really need to do for an organisation. They try to shift the business process to fit the solution. And that might mean fewer sort of big greenfield, big development projects, less customisation, more configuration. So actually, suppliers may be getting less access or less need for customer materials. So the need for an IPR indemnity, I think, might be diminishing slightly. Just to shift to the far right, so security indemnities, like we actually had never seen these pop up in the samples that we'd taken in previous years, but there were a few contracts in our most recent sample where the customer was having to give a security-related indemnity. So a little bit unusual, but I guess possibly a reflection of some of the sample that we had where it was quite a lot of agile development projects, or that was the predominant methodology for the software builds that we saw, where the teams are working jointly. So there is a bit more of a joint responsibility for certain things, and that may be one reason why we had a handful of contracts where the customer was giving a security-related indemnity. And DP is not on this slide. Faye obviously mentioned there's been a bit of a downward spiral of the need or the desire for customers to give a DP-related indemnity. Okay, so just a couple more slides. Exclusions of loss. So this is a bit of a word cloud. The bigger the word, the more frequently it is excluded in contracts. So no huge surprises here. You'd expect to see indirect consequential losses, loss of profit often excluded. The 2 points I guess we wanted to make on this particular slide is from a supplier's perspective, it inherently feels quite good to have excluded loss of profit from the liability or from your own liability. But if you're having to give that as a mutual exclusion, you need to think about, your charging mechanism and termination payments, because you're otherwise potentially excluding the very type of loss that you'll suffer. If a customer breaches and the contract ends up terminating earlier, you won't have that runway to recover that revenue or profit that you might be expecting. And then from the supplier perspective, the one I wanted to pick up, it's slightly smaller on there because it's only 34%, but looking at exclusions of loss of data. So I know some of our quite savvy customers already think about this closely, but have a think about that interaction with data protection losses. So they're not all going to be loss of data. You can suffer other losses because of DP issues, but if you're accepting an exclusion of loss of data as a blanket statement, you might be actually barred from recovery for certain types of data protection losses. So you might have a great DP cap, as Faye was saying, at 300%, but if you can't actually recover that type of loss, then the cap is pretty meaningless. So I think this is our last substantive slide, and this was just more about deemed direct losses. So in the UK market at least, this has become super common. So as the chart on the right says, in 83% of the contracts we survey, and in pretty much all the big deals that we see, there's always a discussion, and usually now some provisions about deemed direct losses. And so out of those 83% of deals that we saw, what you can see on the right-hand graph is what percentage of those particular heads of loss appeared within the contract as a deemed direct loss. So, it avoids that need to have that argument with the supplier as to whether or not the loss is recoverable at all. And I guess what's interesting to see here is that, certain ones of these are really common. Additional operating costs, the cost of procurement or reprocuring a new solution. And I think this represents a fairly pragmatic approach by suppliers who are going through a process about trying to get the deal done. And that I think reflects the fact that a couple of those, especially the top two, in most cases are likely to be direct losses anyway. So it's not a massive give for a supplier to concede that, but it does help in the negotiations. The one thing I guess I wanted to point out on this one is the very bottom one, wasted expenditure. So we were a little bit surprised to see that down at around 30%, because if you think about it from a customer's perspective, wasted expenditure might cover, the charges you've paid to the supplier, and if actually what you've received isn't workable, doesn't function, you've got no value out of it, you might want to try to recover that as a wasted expense, but that's not always going to be a direct loss at law. So it was interesting that it wasn't super high, but maybe that will continue to grow over the years. And just the last point on this particular slide we wanted to touch on was that sort of recovery of data, regulatory fines and penalties, and that obviously plays into the data protection discussion we've had today, and sort of goes hand in hand with seeing a slight drop in the number of DP indemnities that we're seeing, but there's a fairly healthy number of contracts, like 65, 80%, that have some type of data-related deemed direct loss. So that's one way that you can still try to mitigate the risks if you're a customer without a DP indemnity.
Okay, so I appreciate we've kind of thrown a lot of data at you, a lot of graphs and diagrams, and you're probably dying to get out for a drink. If you take anything away from this session, we thought it would be worth just highlighting a few kind of key takeaways from the stuff we've been through. So just starting at number one, I think our general feeling is that there isn't very much point as customers for holding out for uncapped indemnities. Other than the areas of kind of IPR and 2P, we're really seeing that these are just not market anymore, particularly as we mentioned in the case of data protection. And so doesn't really seem to be something worth pushing for. On the supplier general liability caps, as we mentioned, whilst our data shows that the value of these is slightly going up, we actually think that it's not really representative of market and that suppliers are kind of becoming a bit more conservative. We're seeing these stick down at more like around about 150% of fees. That said, as I talked about, number 3, we are seeing separate caps for a lot of matters, particularly in the area of data protection. These are becoming really common. Often data protection will be data protection liabilities will be capped a lot higher, so around the kind of 200, 300% mark. And just in terms of what I was talking about earlier, in terms of whether the fees are linked to, the caps are linked to the fees over the annual value of the contract or the total value of the contract. We find with data protection caps, it tends to map the general liability cap. So if the general supplier liability cap is linked to 12 months fees, the data protection cap will likely be the same, albeit at a higher value. As we talked about, number 4, data protection indemnities are becoming less common. Where we do see them, they tend to be drafted more narrowly. But conduct of claim provisions are becoming more common where there is a data protection indemnity. So that's kind of on the up, although the indemnities themselves are on the downward slope. And customers really need to justify it if they do want to have an indemnity. Number 5, so as we mentioned, we think that deemed direct losses are becoming a lot more common and perhaps are sort of taking the place of the specific losses that were previously indemnified against. So this is the things we mentioned, things like regulatory fines relating to data protection breaches. So deemed direct losses might be a sort of different way of getting this protection rather than having an indemnity. And finally, as I talked about at number 6, there's clear movement away from having unlimited liability for confidentiality breaches. In the last few years, we've seen caps on liability go up from sort of under 20% of the contracts to seeing them in around 40% of the contracts, and I suspect that will continue to rise. So that's certainly something to bear in mind when you're drafting the provisions around confidentiality.